to every one of you. Thank you for being here on this late night or an early night for a great topic from the Medical Legal Society. May I request our State President to give his opening remark? Dr. Senguttuvan, sir, please.
Thank you, Dr. DNR. Respected President-elect Dr. Sridhar, past President Dr. Kanagasababadi, past President Dr. DNR, Honorary Secretary Dr. Karthik Prabhu, Gauri Shankar, and our legal advisor Mr. Anand David, and who is going to give his opinion, and Dr. Nikhil Dattar. He is going to give a very wonderful topic, that is do not hesitate and right to die with dignity. He is an expert in this field. He is a leading senior gynecologist and also a lawyer. So many of for law from the last time, this time they have increased number of participants are there. It is a very good move, and Dr. TNR is giving very good, wonderful topics every time, and he is doing his phenomenal job in the medical legal case. With these few words, I go to Mr. TNR, sir. Please.
Thank you, sir. Thank you for your encouragement and words of wisdom. May we have Dr. Abul Hassan, the immediate past president, if he is there, to give his words. I think he's not there.
Abul Bhai is in UK with Jayalal-ji.
Okay. Yes. Then shall we have the president-elect, Dr. Sridhar, sir?
Yes, Ji. Thank you. Good evening, everybody. The most respected President Senguttu Anna, Karthik, Gauri, and the legal committee chairman, Dr. TNR, ably guided by Dr. G.S. Kumar, Ilangovan, and our past legal committee chairman, past state president, Dr. Kanagasababadi, and the star speaker of the day, Dr. Nikhil Dattar, our own legal counsel and guide, mentor, whatever you add any number of adjectives to him, Mr. Anand David, and all the delegates who are going to benefit a lot from today, what is essentially still a controversial legal topic as far as the Indian law scene is concerned, the right to die. When the Constitution has an Article 21 as right to live, why should not be included an article which will be a right to die as well? Here, the only possible problem is criminal abuse of the act, like the abuse of dowry harassment act and such things, where more people abuse it than use it to benefit. The only fear in bringing out such an act or law as to right to die will be a criminal abuse of it. Otherwise, any dying patient where the death has been already encrypted on his forehead without any any medical help, which he cannot come out of it with the best of treatment, I think it should be given him that right to that particular dying person to die in a dignified and in a medical manner with least pain and aggravation. And the family should be given the right to decide on that. I think today's discussion will focus on such issues, and maybe with a collective opinion, we can approach the government of India in this regard. Thank you, Ravi Shankarji. Over to you.
Thank you, President-elect, for your words of wisdom. It's a turn of our dynamic secretary, Dr. Karthik Prabhu, to give his wisdom on this vital topic.
Thank you, Ravi sir. Most respected President Sridhar sir, all past presidents, and our dear Anand David sir, and the speaker of the day, Dr. Nikhil. Good evening, everybody. Ravi sir, I really congratulate you. Topics you are taking, and which is very, very practical. Definitely from our MBBS days, we always write in the case sheet, DNR, do not resistate, do not resist. But what is the legality behind it? And whom we can do, how we can do, what we can suggest, can the patient make a call? There are a lot of legalities involved today. This is going to be a very sensitive topic also, because if something goes wrong, as you know, there has been some hospitals closed because of organ transplant. Now, immediately anything goes wrong, from transplant racket to so many things, they will barge in telling that these hospitals are doing this in particular purposefully, so that they want to harvest organs and things like that. Both may be connected. So unless we are very clear in what we tell, tomorrow even the good things if we suggest will land up in trouble. And for this we have the right person, Dr. Nikhil sir. We have heard his talk earlier, fantastic person. And of course our Anand David sir, I would always call, is more than Anand David advocate, is Dr. Anand David, because he knows more legal knowledge than what I do. So, and of course, our legal committee chairman, Ravi Shankar sir, and this team doing wonderfully well. Best wishes, sir. We look forward to hear from you. Thank you.
Thank you, Karthik. Can we have our young finance secretary, Dr. Gauri Shankar?
Sir, he's held up in an emergency, sir. So he just conveyed it.
Sir, please can go up, sir. I'm here only. Karthi, sir.
Okay.
I'm here.
Okay, fine.
Yeah. Thank you, Ravi Shankar, sir. As Karthik has spoken what I have thought. So it's on Ravi Shankar sir's part. He's excellent in selecting the topics, and among all topics, this is the most important topic for all the beginners who are starting their practice, and also with the selection of the speakers. Both our Anand sir and our Nikhil sir are excellent speakers. So thanks for the opportunity, and this team is doing exceptionally well. Thank you, sir. Please go on, sir. Thank you very much, sir.
Thank you to all the dignitaries, and I will request all the other dignitaries also to stay back till the end, like Kanak sir, Dr. CMKR, Kantikar will be joining, so that they all give their expert opinion at the end of the session. And may we have our excellent speaker, the much awaited Dr. Nikhil Dar, to give his talk. Karthik sir, I was just seeing a newspaper clippings when it showed that Mumbai, one of the High Court judge had given a medical will, and then it was Nikhil Dar's name was there. Now the next person who had given a medical will. When I tried to put the topic as medical will, Nikhil sir gave me the mutated topic, so that now we see lot of hospital owners in the webinar. They are the people who know the difficulty, who have undergone the troubles, and already the first question has already come into the chat box. Let me not waste the time. May we have Dr. Nikhil Dar. He is the person who has done individually public interest litigations and court cases. He is the person who was primarily in charge of getting the MTP Act revised from 20 weeks to 24 weeks. It was an individual PIL filed by him. And I asked him, what is the usual cost for you to do a PIL? He said 5 lakhs. Occasionally the lawyers, maybe like Anand David sir, not charging us. That is how he is able to do, and he has got lots and lots for the medical community. He will provide us, and today he will give us the knowledge of the medical will in a mutated way, the topic what he has designed. Nikhil sir.
Ravi sir, chairperson's comments.
Anand sir.
Yes, thank you, Doctor.
Yes,
and it's always a pleasure to be with IMA. And the topic selection is excellent, because it's one of the it's a need of the hour, because this particular topic, right to life and right to die, there is no legislation that governs it. So it becomes all the more precarious to circumvent the legalities around this. So, but the courts have laid down guidelines, and I'm sure our speaker, Dr. Datar, will be able to throw more light on that. And then after that, I can join in after that. Thank you.
Thank you, Anand sir. Nikhil sir.
Thank you, sir. Thank you. Can I share my screen so that my presentation?
Yes, sir. Yes, sir.
Thank Indian Medical Association Tamil Nadu branch, and particularly Dr. Ravi Shankar sir, for giving me this opportunity to talk to all of you all. And I want to particularly also thank the state president, the immediate past state president, the president-elect, Dr. Sridhar, Dr. Karthik, Dr. Gauri Shankar, and of course, Advocate Anandji. The topic that I'm going to talk about is a topic which is very close to my heart, and I can talk on this topic for maybe half a day. So I want to first of all know that how much time do we have, so that I can tailor my discussion in accordance to the time that we have at our disposal.
So 30-35 minutes, and then discussion will be more productive, sir.
Okay. So I will skip this introduction. You have already put this introduction over there earlier on. The only special thing that I will like to say is I am one of those doctors for whom law and teaching law has been a passion. So I am honorary professor at the National Law University, but I have never taken law as a profession. My medical practice as a gynecologist is my profession, and law has always been my passion. Many of you must have seen this Times of India clipping way back in 2023 February, pushing the movement to seek dignified death. This was an article that was published in Times of India, and you can see my picture with a letter in my hand or a paper in my hand, which is nothing but advanced medical directive or a living will, as it is called as, which is what I made for my own self. This was a story way back in 2023, and according to Times of India, I am purportedly the first person, I could be the first person in the country who has made this advance directive in accordance with the Supreme Court guidelines. I mean, I'm very sure that there may be hundreds of people who must have expressed similar kind of wishes in some kind of an informal manner, or writing it into the will, or explaining about this to their family doctors or friends or children or family members. But there is a specific kind of a thing which has been given by the Supreme Court, and I was the person who actually landed up doing it in accordance with how it is supposed to be done by the Supreme Court's guidelines. So obviously, why did I do it? Of course, one thing is that I definitely do believe in euthanasia, and secondly, if I have my skin in the game, then I have a reason to agitate and I have a reason to fight for it. Now, we all know as doctors that today's medical technologies sometimes land us up into such kinds of situations where whether we are extending the person's life or we are delaying the death of the person, that becomes very questionable, and nobody really knows what to do. And as Karthik sir was saying, and as Ravi Shankar sir said, that a lot of hospital owners have joined this meeting. What I have put forth in this slide is not new at all, because sometimes you will have family feud between various people in the family. One brother says stop the treatment, one brother says continue the treatment. One person comes from Middle East and or maybe from US and says that such people, so we make them absolutely totally normal in 4 days in US. What kind of treatment is going on? And on the other hand, there may be a situation that hospital is trying to ventilate person only because they want to extract more money. Somebody may say that it is for organ donation. Somebody may say for something else. And somebody in the hospital may say that if at all you want to stop the treatment or you want to deventilate the person, you take against medical advice, discharge, take the person home, and then whatever happens to that person at home, it is not our responsibility because you have taken the person home. And for the relatives, it's a very big problem because relatives don't know what to do. They don't know how to manage a person who is struggling to breathe. They don't really know, the answer to the question what other relatives and people around them will say, that you are not taking care of your father, or you are not taking care of your mother, or you are not willing to spend money for the health of the father, so on and so forth. So unfortunately, this is what is the situation that happens, that everybody is pointing finger at somebody else. Most of them are pointing finger at the doctor or the hospital. And literally speaking, cat, dog, monkey, donkey, everybody starts pointing fingers to each other. The worst part of the story is that dying old man, who is probably unconscious, who is probably vulnerable, who is probably in extreme pain, he is not able to express what he is going through. He is in a very ill-dignified kind of a situation. And nobody is really looking at him from his being there in the point of the center. Everybody is trying to solve the problems in accordance to what is more important to them. And this is typically what happens today as far as we in medical care are concerned. Well, right to die, euthanasia have been topics of legal debate, dramas, movies, novels, discussions, conferences, all those kinds of things that we all know. And slowly and steadily, we also know that death, euthanasia bring in some kind of a legal issue. How do you distinguish between suicide and euthanasia? How do you distinguish between culpable homicide or withdrawal of care? How do you distinguish between palliative care or comfort care and side effects of high dose of a drug, let's say morphine, leading to a death? So how do you distinguish between these kinds of concepts? So these have always been a problematic situation for us. And look at our code of medical ethics. Our code of medical ethics in itself in chapter 6 says that practicing euthanasia is unethical. The only exception to that is if at all the person is brain dead, and that too if that brain dead person is going for organ donation, only then can you withdraw the support. Otherwise, you are not supposed to withdraw the support. If you do so, then it will be considered as an unethical act in accordance to the Code of Medical Ethics. So this is the background with which we actually land up, and that's why we have all these questions, because we actually do not know what is the latest legality on this particular subject. Well, there was a case which was filed called Common Causes versus Union of India, and this case was there in the Supreme Court. The Supreme Court, as a matter of fact, had very clearly said that at this point of time in our country, active euthanasia is not allowed. So I can show you this picture of this old couple on the left side of the screen. They were almost 90 years and living in Mumbai, and they had appealed to the court that they just simply want to die and please allow them to die. And unfortunately, the court said no, that's not possible. So active euthanasia in our country is not allowed. However, the judgment, Common Causes versus Government of India, has very clearly said, the Supreme Court has very clearly said in the judgment that passive euthanasia is a right of every citizen in our country. So there is a lot of discussion that they have done on the right to die with dignity, right to life under Article 21, whether right to life under Article 21 also embodies right to die and right to die in a dignified manner. So all this discussion the Supreme Court has done, and ultimately Supreme Court has come to a conclusion that in our country passive euthanasia is allowed. However, the Supreme Court has given a kind of a framework to follow. So the Supreme Court has said that there are certain things which citizens should do, certain things that doctors should do, and certain infrastructure the government should provide. And if all this is there, then one can very confidently, in a legitimate manner, actually speaking, provide passive euthanasia to the patient. When this judgment came, the first judgment or the order that was kind of given by the Supreme Court, the standards that were laid, they were so high and so difficult that though there were people who were willing to do this, they were not actually able to do it. So I want to give an example of Dr. Lopa Mehta. She is a very revered professor of anatomy. She used to teach all of us in KM Hospital, which is a very revered hospital in Mumbai, teaching hospital. And when Mehta madam decided to do her own advance directive, even she was not able to fulfill the criteria for the same. And that's why, literally speaking, nobody was able to do so. And that's why nobody was able to do this particular thing. Finally, there was a miscellaneous application which was filed by the Indian Society of Critical Care Medicine. And they said, and they actually told the court that, well, you have accepted, but the kind of guidelines or the framework that you have given is factually not possible to fulfill, which means in turn that order is there, but it cannot be implemented on the ground. What is the use of that order? So you need to bring down, the requirements for it, and that's why this particular judgment was given somewhere around 23, I think end of 2023. This judgment was given, and as soon as this judgment was given, in a span of just about a month's time, I, in accordance with this particular judgment, made my own advance directive or a living will, and the whole thing started from there forward. So I am going to take you through the journey of this particular thing and how I have built this particular movement across in Maharashtra and also in the country in terms of making people aware of their rights about passive euthanasia what they need to do, and how the system needs to be made. So we need to know what is the framework given by the Supreme Court, what citizens are supposed to do, what hospital owners are supposed to do, and we should talk about its impact on medical practice, insurance, organ donation, etc. I mean, some of the questions were already raised by the senior people in the organization. So at the end of it, we will take these questions probably and try to find out the answer. We have multiple terms: living will, advance directive, medical power of attorney, do not resuscitate, passive euthanasia, of which do not resuscitate is typically a medical word, medical phrase that we all know of. And passive euthanasia is typically a kind of a more palliable kind of a term to the lawyers and to the advocates. Advanced directive or advanced medical directive is a well-known concept in the Western countries. Medical power of attorney is also a well-known concept in the Western countries. So many times these things get kind of used alternately. There are minor differences, but ultimately they all aim at a particular place, which is somewhere to do with passive euthanasia. And it must be very importantly said that just expression to your near and dear ones that do not put me on ventilator or do not, give me a shock or something of that sort is not enough, because it does not have the legal sanctity. So, if you really want to have a legal sanctity to your wishes, then it is mandatory for you to make a document which has a legal standing. And that is why advance directive happens to be a legal document whereby you express your choices about the medical care at the end of your life, especially so when you are incapacitated in decision making. If you yourself are able to communicate, then there is not a problem at all, because you, of course, being conscious and able to communicate, can always withdraw the consent for the treatment. But if at all you are not, and typically we all know, being doctors, that when you are so seriously ill, usually you will be unconscious, and some other relatives will have to take decisions on your behalf. So that is why, to guide those relatives as well as the medical team, this written document is going to help us a lot. So typically, advance directive is a kind of a document which any adult can make. It is exactly like consent, so I'm not going to waste my time in talking about all these things. More particularly, in this document, we are going to talk about what kind of treatments that you don't want or that you want, or more particularly, I would insist that all these advance directives must particularly say that pain alleviation or anguish alleviation treatment should be an integral part of the treatment. So palliative care is going to come big way, and it should be coming in a big way for maintaining the dignity, because as everybody knows and agrees that pain is a very, very significant factor because of which the person's dignity comes to stake. So having pain-free or minimalistically painful, so comfort care is what actually speaking is required. So typically in advance directive, you will write about your choices about various things. These are just some of few things which I have written, but I'm sure many people might want to omit or add or whatever that is there. So these are the things that you will talk about. You may want to talk about organ donation, but I completely agree with you that organ donation currently by society and community is seen as one of the ways of making money for the hospital, so on and so forth. So it becomes a bit shady from the public perspective. I mean, that's where the societal attitude needs to be changed. Although actually it is worthwhile doing, we all medical men definitely believe that such things should exist and should be routinely done. In fact, I would say countries like Singapore, where unless you refuse organ donation is supposed to be done, or it is automatically done. That's the system that they have in Singapore. Ideally, that is what should be the system, but we are very far from that. So I am not going and digressing into that organ donation discussion at this point of time. And pain relief is, of course, going to be important. The contents of the draft, I am not going to go much into the details. Here it is very important that you must clearly write the name or the names of the person to whom you are going to give the authority to take the decision on your behalf. And it is very important that you give clear instructions to that person. You have to tell that person that, look, if I have lost my consciousness, you are the one who are going to take the decision, but you are the one who is going to take the decision on behalf in accordance to how I feel about the situation, not in accordance with how you feel about the situation. So he has to put himself in my shoes and then think about it and take the decision. So those are the names that we need to write. Then additionally, you need to notarize this document with two independent witnesses. So you go there, notarize the document in front of a notary with two independent witnesses. You do not require any stamp paper. You do not require any registration formality. You do not require any legal paper for this particular thing. David sir will agree that typical will also does not require registration, but it is quite common to register the will. Here, the Supreme Court has suggested a quasi-judicial authority called a custodian. So, in short, it is expected that the state shall appoint custodians at all the places in the state, and these custodians are the ones where you are going to go and submit a copy of your advance directive to them, and they are going to put a seal on your original paper or on your original copy. And this whole thing has been done obviously by the Supreme Court to ensure that there is no abuse or misuse. Somebody was saying that, so there is no abuse or misuse of law, because when I go in front of the third party and I submit it, it is obvious that that third party can recognize that this man has come voluntarily, he is not under any force, he is conscious, he is able to comprehend what he is saying, and that's why there is no question of any abuse or misuse or something like that. And that's why this particular mechanism the Supreme Court has suggested as the custodian, as the quasi-judicial authority. So, in short, the part one of the story is over. I wanted to decide what I want and what I don't want. I wrote it. That's an advance directive. I submitted to the custodian. Now I have the seal of the custodian on my advance directive. Copy has been given to my relatives. Now cut to maybe 10, 15, 20, 30 years later, I don't know. I am in the hospital in a terminally ill condition, where the treating doctor tells my relative or my son or my daughter that your daddy is not in a good condition. He is not really expected to recover. We can only prolong his life and wait for the God to act, but otherwise meaningful recovery is not expected from him. And at that point of time, it is expected that my son or daughter, whosoever is the person who is a witness or whosoever is the person who is the executor, will carry the copy of my advance directive and give it to the doctor, saying that my father had made this particular document. So please go through this document, and if he has reached that particular stage as expressed in the document, please kickstart the next process of giving him the passive euthanasia mechanism. So doctor typically will confirm the authenticity. He may do so by going through the digital records whenever they are available. Currently in Mumbai and Maharashtra, we don't have digital records, but because of my public interest litigation, by August, we will be having a web portal in Maharashtra state, and these records will be available digitally for people to confirm the authenticity. Now, the role of hospital and doctor comes into picture. So, at any hospital, this is nothing to do with government hospital or non-government hospital. At any hospital where the patient is admitted, the treating doctor, the hospital administration, is expected to do following thing. And this is what is the Supreme Court that has told. It is not what I am telling. This is the judgment by the Supreme Court. So the Supreme Court says that the treating physician and two subject expert having whatever 5 years experience or whatever. So 3 doctors basically will examine the patient and within 48 hours and make their opinion as to whether he is really at a point of no return or not. If they say so, that he is at a point of no return, then the hospital is supposed to constitute another board that is called as secondary board, again having 3 doctors, but these 3 doctors have to be different than the previous 3 doctors. They may be from the same hospital, they may not be from the same hospital. Out of these 3 doctors, one doctor or one RMP should be a nominee of the Chief Medical Officer of the district. So the role of the government is only restricted and limited to creating a mechanism to nominate one RMP who shall work on the secondary board. Otherwise, 3 doctors from the primary board and 2 doctors from the secondary board are not supposed to be having anything to do with government or government facility. They need not be government employees. There is nothing. Every state can decide how do they want to kind of create this mechanism of nomination of one RMP. That's entirely up to them, and that's only where the government's you can say interference, if you may call it as, or role will come into the picture. And another 48 hours this secondary committee is supposed to see. So I feel that they have given 4 days time. So sometimes we do see some miracles happening, and if at all suppose in 4 days, if the situation starts improving suddenly or some such kind of thing happens, then I think that's the time that has been given by the Supreme Court for those miraculous recoveries, unexpected ones to happen. And if at all they do not happen, then by the end of 4 days, that's 48 plus 42 2 hours, the primary and the secondary board will come to a conclusion. And once they have come to the conclusion, they will officially, in legitimate manner, inform the JFMC, not take consent of the JFMC, just simply inform the JFMC, the judicial magistrate of first class, and they will withdraw the life support or withhold the life support, whatever the case may be. Give them good amount of painkiller, give them good amount of palliative care, give them a natural death certificate, and allow the person to die in a very peaceful and a dignified manner, not prolonging his death unnecessarily. That is the mechanism which has been suggested by the Supreme Court. Now the questions are that are we aware about it? Are we involved about it? Are doctors updated and willing to take this responsibility? Many of the doctors are not even aware, and they are not even aware. They are neither aware or updated, and they are not willing to take the responsibility only because they are very unsure whether they will have the immunity or not. But now, after understanding that the Supreme Court has given this particular kind of a judgment, many doctors will have the sense of confidence that this is perfectly all right to do nothing wrong in it because this is perfectly legitimate and legal. So, this is what I mean by legalizing or legitimizing the do not resuscitate, because up till now, what happens is that we take consent like do not resuscitate, end of life. But the truth of the fact is, even if somebody writes on DNR or somebody writes on end of life, the truth of the fact is no doctor in any hospital in the country has the guts to just simply remove the tube and allow the person to pass off. What they will do is that, though the relatives have said whatever, they will not escalate the ventilatory setting. They will just kind of keep it like that, So they will just do some kind of a dilly-dally type of a thing whereby everything looks appropriate on paper. But the truth of the fact is that they have got a DNR kind of a consent, because everybody knows that really speaking, do not resuscitate, though is a perfectly medical concept, was never a legal concept. It was never discussed by the law of the land. Up till now, it was considered to be euthanasia slash homicide. Now the Supreme Court has gone further and created an entity called as passive euthanasia, which becomes a legitimized mechanism of do not resuscitate. So this is what typically speaking happens. Now, coming back to my story, after I did my advance directive and created one copy, I realized that in Maharashtra state, factually speaking, there was no custodian on the appointed. I was supposed to give it to the custodian, but there was no custodian appointed. So for almost about a year, I was filing RTIs, I was communicating with the commissioner of Mumbai and all that. And then I realized that actually speaking, nobody has done anything on this particular judgment given by the Supreme Court. So Supreme Court judgment is a fantastic order on paper, but there is zero work which is done on the ground by the state of Maharashtra. So ultimately and finally, while on one hand I was talking about this to media houses and making people aware of it, educate them, this is Times of India editorial page article. In fact, being the professor of National Law University, we have our own young brigade of lawyers. So we have our pro bono club. So our students from the pro bono club started helping. They helped nearly 100 people to make their own advanced directives completely free of cost. So these were the things that were happening. And ultimately, at the end of the day, after nearly about 7 or 8 months, I filed a public interest litigation in the Bombay High Court stating that the state has failed to set up the living will mechanism as given by the Supreme Court of India, and that's why they should be directed to do so. So, in this particular public interest litigation /3 of 2024 in the state of Maharashtra, which is Professor Nikhil Datar versus State of Maharashtra, the Municipal Corporation of Mumbai, Union of India. And then I further added the National Medical Commission also, because as you all know, and which is what I have already said, that our National Medical Commission and its Code of Medical Ethics still is very archaic. Okay, it needs to be brought up in level and line with the Supreme Court judgment, because our Code of Medical Ethics is only going to allow us to do so if at all a person is brain dead, or and that too not only brain dead but brain dead and wanting organ donation. So that's what is the situation of the Code of Medical Ethics, which also needs to be changed. So these are the opposite parties that we appointed, that I had in the case, and my prayers were: A, that the state should appoint custodians; B, that there should be a mechanism of appointing the doctors to represent the chief medical officer; C, there should be a mechanism to have digital records in something like DigiLocker or Abha, so that they can be referred to from anywhere in the country; D, to create sufficient amount of awareness amongst the citizens as well as amongst the doctors and the hospitals; and lastly, of course, to amend the Code of Medical Ethics suitably. So my whole effort, by the way, I am not an advocate, so I technically cannot represent even myself in a public interest litigation in the Bombay High Court. But I decided to argue my matter myself only, and for which, according to the rule of the High Court, 2 judges of the High Court actually interviewed me first and checked my competency to argue, and only upon being satisfied with my competency to argue in front of the Chief Justice, I was allowed to appear in person in this particular PIL. But my efforts were significantly lauded by the Chief Justice, and the first breakthrough came in just about 2 months, where just on 8th of March 2024, we were supposed to have our hearing. But on 6th of March 2024, the Maharashtra state passed a GR stating that they are going to, via this GR, appoint 413 officers as custodians in our state. So this was the first breakthrough that I got. And as soon as this happened on 8th of March, on 16th of March, I went and submitted my advance directive to this gentleman called Dr. Bhupendra Patil from the Municipal Corporation. So he happened to be the first custodian in the country to receive such kind of an advance directive, and I happened to be the first to submit such kind of an advance directive to him. And then slowly and steadily, as and how the things started spreading, now we have 3 judges from the Bombay and the Goa bench, who have made their own advance directives too. So as and how the things are progressing, many people are coming forward and doing this particular. In the meantime, the central government also issued a draft guideline in terms of what needs to be done, etc. The state of Odisha has created a guideline on how do you appoint the officer or the doctor who shall represent the chief medical officer. So this is what is typically what has been the story. Now I have filed RTIs across all the states already, and I have data compiled. So I have realized that except very few states in the country, most of the states have not worked on this. So I am working towards filing a PIL in the Supreme Court on this particular issue as well. So I do not know when this will materialize. I hope that it materializes with the good wishes and help of all the dignitaries of IMA, David sir, so on and so forth. So probably we'll be able to do this recently. Now, a lot of people ask me this question, that we understood the concept, but how do you make your own advance directive? Of course, there are your lawyer friends who can help you, but what I have done is that my draft of my advance directive, I have kept on my website for free download. So, a lot of people in the country are going to my website, drnikhildatar.com. They go to this red button and just simply download the draft of my advance directive. Of course, I don't want them to use the draft the way it is. I want people to read through, understand, make necessary changes, and create their own draft. So it is not a cut and copy paste kind of a job is expected out of this. But this can work as one of the reference documents, and there can be many such reference documents that people can use. So finally, my PIL was disposed of on 17th of April 2025. It took almost about 1 year and 6 months by the Bombay High Court. And because of this particular thing, now the state of Maharashtra has been directed and given 4 months time from April. So now August will be 4 months to create a web portal for living will registration. They have directed the National Medical Commission to make suitable changes to the Code of Medical Ethics. And more importantly, the Chief Justice has said that if I am not happy with what the work Supreme State has done, then they have told me that I can go back to the Chief Justice and kind of argue or file a fresh PIL and argue my matter once again. So, ladies and gentlemen, I feel that this is a point of point where we all need to chip in, and different people can help in this particular way. We as doctors play a dual role because we work as doctors also, and being citizens, it's important to know that we all also need to make our own advance directive and make some such kind of choices. So we are in a unique position whereby we can make our own advance directive and also bring and handhold our patients to help them to make such kinds of advance directive. More particularly, my appeal to IMA that if they take a very proactive stand with the government and the National Medical Commission to make suitable changes to the Code of Medical Ethics and also harp on ensuring immunity to the doctors who are going to work on this particular panel, then it will be the greatest service to the mankind and to the senior citizens and to those who are terminally ill in our country. Of course, I mean, people can donate because we have a pool of money through which we help people to make their own advance directives. So that's, of course, monetary donation and contribution is most welcome. So up till now, this is what has been my journey. So I just kind of narrated my journey so far, and this is where I am at this juncture of time. So I think we can now have question answer session that might be very important and fruitful. Thank you, ladies and gentlemen, for patient hearing.
Excellent and elaborate talk, sir. Thank you. Let's have our expert, Anand David, sir, advocate who has been turned as a doctor to give his expert opinion on the whole issue. And while he was talking about Maharashtra, how we can take it in our state, that's what we wanted.
One thing, sorry, sir, sorry. I, for the want of time, Supreme Court judgment is very elaborate. I mean, they have talked about what if primary board doesn't agree and secondary board agrees, and what if secondary board, all those kind of permutation combination. They've also spoken about how many times can you make the will. You can make them unlimited time, like will only. The last will kind of prevail. So there are a lot of these provisions which are there. Just for the want of time, I have not elaborated on those provisions. But somebody who will go through the Supreme Court judgment, they will find these elaborate things in that order. Sorry.
I'll request you straight away if you can write an article and give it for the IMA Tamil Nadu state. We will be able to publish it in our state journal, our PPLSS, which is taking care of the doctor as well as the nursing home board. Nursing home board, where the whole issue is going to be of a good one. A law, if it's created, is going to help us. Anand sir, your expert opinion, please.
Thank you, Doctor. I think Dr. Dattar has comprehensively covered the topic. Now, I'll just be very brief and take you through the history of how this evolved. Initially, in the year 1994, till then there was no talk about this. 1994, there was a case, P. Ratnam versus State of Punjab. There, that was the first time where they had visited this issue of DNR and 309 IPC, which is abetment attempt to suicide, which was a criminal offense, was visited, and they said that that was removed. And so right to die was brought in. Then subsequently, immediately in a span of 2 years, there was another judgment by the Supreme Court which overruled that. That was Jian Kaur versus State of Punjab, where they said right to die cannot be there. Then they said right to life under Article 21 of the Constitution, it does not include right to die, but it does include right to live with human dignity. So they kind of shaped the law. But till lately, till at least 2006, There was a law commission, and then again 2008 there was a law commission. They had in detail debated about it, but nothing much came out of that. No law, it didn't become the law of the land. But then, as you all know about the Aruna Shambhag case, which came in 2011, where passive euthanasia was discussed, and the Supreme Court had passed certain guidelines. The main ones being they legalized passive euthanasia. They rejected active euthanasia. That's the administration of lethal injection. All that was made illegal. And they also, for protecting the doctors and hospitals, a decision was taken that even the family or the doctors alone cannot decide on euthanasia, and it has to be done only with the sanction of law. So this is what the Shenbog case brought in. Then there was again a gap. Then came the 2018 Common Cause versus Union of India. This was the first time the Supreme Court legitimized living will, and they passed a very detailed judgment where guidelines were laid down as to how a will has to be made, and how, as far as the doctors are concerned, how to go about it, how a committee has to be formed, how a secondary committee has to be formed. All that was formed. But what happened was, after that judgment came into vogue, they found that it was, though it was in detail, there were some loopholes in the judgment, and there were some practical issues which needed to be addressed. Now, when I say practical issues, things like that earlier judgment talked about a magistrate has to, you need to go get a signature from a magistrate. The magistrate has to visit the patient, and all that is practically not possible, because especially magistrates are also very busy, and we all know that when at the time when at a very critical juncture, when the patient is unconscious, it will not be practical for the family to be running around courts and approaching magistrates for these kind of signatures and stuff. So what happened was, a miscellaneous petition was filed in the Supreme Court, and in 2023, the Supreme Court modified the guidelines. They modified the guidelines to such a great extent where it was made very patient friendly, where this issue of signing by the magistrate was removed, and they said only all you need to do is go get a notarized notary is enough on a living will, and a lot of things were watered down, and that became the law of the land. As you all know, in the absence of legislation, Supreme Court guidelines will be the law to be followed by everybody. In fact, what has happened is, even at the time when this case was in the Supreme Court, the central government had made a representation saying that they were not interested in bringing out a legislation. So that is the reason the Supreme Court went hammer and tong, and they said they took it upon themselves to frame these guidelines and make it workable, and make it a law of the land. So now, coming back to what we can do is, as Dr. Datar was saying, there are some custodians who have been named in the guidelines. When I say custodian, what it means is, uh, like how we go to a sub-registrar office in Tamil Nadu to register a document, that though a will or an ordinary will is not a mandatorily registrable document, sometimes to rule out fraud by the family or whoever, because sometimes what happens is, after the person passes away, the will is challenged in court, saying that the will is forged. He did not sign the will, somebody has impersonated him, forged the signature and all that. So to avoid that, we have this registration process in the sub-registrar's office in Tamil Nadu. But here, as per the Supreme Court guidelines, what they say is, some custodians have to be appointed by the government, state government, so that these wills, these living wills, can be submitted to these custodians when a person is of sound mind and he has a capacity to do it. So when this is like, I can draw a parallel to your registration of your will before the SRO. So when these documents are submitted, then it becomes easier at a later stage to, when these wills have to be acted upon, it becomes easier for the family as well as the hospital to take the will from the custodian and start the process of acting on that living will. Now, in Tamil Nadu, there is, as on date, there has been no custodians who've been named. There is no procedure for that. So what we can do is, in fact, as the IMA has been pioneers in that, what we have done earlier is, if you would remember, when we wanted to implement the guidelines in the Jacob Matthew case, we had approached the Madras High Court to implement that, and the High Court had granted time for implementation, and they had given directions to all the police stations to circulate the judgment and make it workable. In the same way, if we can start the process of a dialogue with the state government at the inception as the first step, and then take it to the courts, because we need to exhaust the remedy, whatever is available to us, like giving representations to the state government and getting their replies, and see whether the custodians can be appointed at that stage itself. And in case that is not workable, we can always go to court, and since it being a Supreme Court guideline, I'm sure we'll be able to get it in no time, a direction from the court to appoint such custodians, so that the living will becomes workable. So I think I'll just curtail my topic as of now, so that we'll have time for the discussion and the floor to be open for questions.
Thank you, sir, for giving the history of the entire process and giving us a way forward for the IMA Tamil Nadu and for the doctors in Tamil Nadu. Thank you very much. May we have the expert opinion, Dr. Kanagasababdi sir, our past president. Kanak sir, any input from you? If you are sitting there, I'm sure you would have already worked up for it.
That is, our council is already given a detailed information about this. We should get the judgment copy from the Supreme Court. We have to approach the Health Secretary as well as Home Secretary to get that the appointment of custodian. If the government is delaying it, we have to no other court. We have to go for the High Court to get the direction from the court to appoint your custodians. First thing is one. Second thing is, we have to create a awareness among the doctors as well as the hospital. That is still, this is a new subject for us. So the doctors are concerned. So we have to, IMA should take a initiative to create the awareness among the doctors regarding this matter. Thank you, sir.
Thank you, sir. Same care, sir. Unmute yourself and.
Good discussion, Ravi.
Thank you.
Congratulations to Dr. Datar. I think he did a lot of homework on the subject. Some countries actually even active euthanasia is illegal, like Switzerland, Canada, and Denmark. Some countries, but mostly active euthanasia is illegal in almost all the countries. Passive euthanasia, as already mentioned, Supreme Court has given some guidelines. I think that should be publicized, and all the hospitals should be aware how to produce passive euthanasia and what is the custodian rules and all these things. I think many of us, even I did not know till today that this custodian issue. So I think we have to make it, all the hospital owners should be aware of this issue, and we should approach the government. In Supreme Court direction already is there. It should not be difficult to get us the direction from the High Court. And finally, of course, after the organ transplantation has come, some changes have occurred in the brain death situation. Virtually amounts to passive euthanasia only when you pull off the plug after the organs have been harvested. So I think the most important thing is, as Kangasabha said, we must create awareness among the doctors and the hospital owners, because many of them are not familiar with these procedures, and I think they may get into trouble not knowing the judicial process. So, but otherwise, I congratulate Ravi for selecting the subject, which is very sensitive and invites a lot of litigations if not properly followed. Thank you. Thank you.
Thank you, sir. Thank you, sir. Somebody was raised their hand. Avinash can unmute and ask the question. I think our PPLSS secretary, Dr. Chandrasekhar, is there.
Kumar இருக்காரு, ரவி குமார் இருக்காரு.
Kumar will come at the end for a vote of thanks and
இப்பே ஒப்பீனியன் ஏதாவது சார் லீகல் மேன்?
Kumar, President-elect wants your opinion. Unmute.
கேக்குதா?
Yes.
The main problem is we must represent to the registry first. Registry, then to the Board of Law Council, Law Commission. எப்படி பவர் மேல இருந்து கீழே வருதோ அந்த மாதிரி கீழே இருந்து மேல போகணும். ஃபர்ஸ்ட் டிமாண்டு, அதுக்கப்புறம் தான் we must go to the legal இது. The government should know the importance. Only then it can be passed as a law. State law வந்ததுக்கு அப்புறம் தான் we can go to the union law. Tamil Nadu branch, I think with the head of active members, Dr. Ravi Shankarலாம் இருக்கிறப்ப at least we must start the train now. இப்போ வண்டியை தள்ளி விட்டாதான் அது போய் நிற்கும். We can do it. As Dr. Qatar said, Tamil Nadu will definitely go ahead with all his principles.
Thank you, Kumar. I think Dr. Nirmal Frederick raised his voice. He is in Delhi doing a NABH inspection for the premier institute of the country. Tough job. Nirmal, your...
Yeah, good evening, sir. Thank you, Ravi Shankar, sir, for arranging this wonderful session. Sorry, I joined a bit late for the Dr. Datta's wonderful talk and heard Mr. Anand David's comments. I'll just add few points to it as from the standards perspective and also my recent experience for my mother's illness. So many of our hospitals do not know about the standard requirement or DNR requirements. So DNR is, just want to highlight few points. DNR is not just abandoning the patient. So we need to continue all other medical care. So only thing, we are not going to resuscitate or do any other methods which the patient has already given in the living will or expressed from the family. So focus more on the palliative care, and only thing it requires proper documentation. So I also visited few hospitals during assessment. In the critical areas, they do not have such knowledge or the documentation requirements. So my concern is all the hospitals who are dealing with end-of-life care patients should have written policies, and the staff, particularly in the ICU and trauma ward, has to be aware of this decisions. And also communication with the patients about the end-of-life care and arrangements. So this has to be literally trained to all our staff. So not only on the emotional aspect, but also on the organ transplant aspect. And allowing natural death is doesn't mean that we are keeping quiet. So if it's the will of the patient, if it's the will of the family, I think we need to let go. So few of these have to be documented in our hospitals, and staff have to be trained. And the legal points also, some of our doctors have to know, particularly the new doctors working in the casualty and in the ICU are not aware of the legal requirements as well as the palliative care recommendations. I think the inputs from the learned speaker and our advocate has to be circulated to all our members. And also you can have some competency assessment for a particular set of doctors who are going to deal with this kind of patients. Thank you, sir.
Thank you, Nirmal. Our state secretary was raising his hand. Karthik, if he is...
Yes, sir. Ravi Shankar, sir. Yes.
Yes, Karthik.
Sir, I have just a very important comment to make after this wonderful discussion. Two things, sir. I think we should follow the principle of natural justice as our constitution says. We come on the fundamental of constitution is based on the lot of Manu Dharma and lot of things. The natural justice phenomenon says, like if anybody who has to decide on who has to be done, should be based on the principles of natural justice, by which what I mean to say is somebody, because money power is so much in organ transplant today that anything can be bought. If I have to buy the kidney of Dr. Ravi Shankar for 5 to 10 crores, there are people ready to buy. It doesn't mean he's been forced to sell. Like that, when problems are going on, what governs this? It should be governed by a group of doctors who are not involved in transplant. I would definitely champion this and take it further, provided one thing: whoever corporate or super corporate may be doing this, the doctors who are involved in the bureaucracy should not be involved in transplant. They need not have knowledge of transplant, but they should apply the principle of natural justice to see whether, okay, what is the expectancy of this patient? Is he willing to die with honor or for money? That angle with the medical background will be the best way forward, sir. Because if you see in the other end, I would come to the other end where people doing transplant, it is so exciting to see you can give a new life to somebody else. Like in Singapore, as what sir has told, naturally things happen. It is still good. So many people from our country go to Singapore for transplants. But the law of the land has to be changed based on a principle, and to as guardians of that principle should not behave medically, should believe in the process of natural justice of that particular person, and for that the background of medical knowledge is there, and such people I think we should promote and take it further. This is what I understood from the whole concept, and anything let me know, sir. I'll be happy to take it further. Thank you.
Thank you, Karthik. Thank you. You have become a social activist with your talk right now. May we have Dr. Selvam sir, who has raised his hand. Selvam sir.
Thank you, Ravi.
Unmute.
Thank you, Ravi. My suggestion is, it's good that it's necessary that we should educate our own fellow doctors, but equally our responsibility also is to educate the public. Because I don't think the society at large is aware. Even we doctors, we do not know. How can you expect the common man to know about this? So it is our duty through organizations like the Lions or Rotary or some other organizations, make this message go to the public, because they are the beneficiaries. No, we may be the helpers, but they are the beneficiaries, people who suffer. So they have to be educated. It is also our duty, number one. Number two, I have a question to the speaker. The person who wants to execute this will, should he nominate only his family member as a person who has to initiate, or he can appoint anybody, nominate anybody as per his wish?
Supreme Court said that he can nominate even the family doctor. That is what the Supreme Court has said.
Nikhil sir, a little louder from your side.
I said that if we look at the order of the Supreme Court, am I audible?
Yes, sir.
So the Supreme Court has said that you can appoint your family doctor also. Okay, so technically, in short, you can appoint anybody.
Anybody. Okay.
And I would say that it is always a good idea to appoint few people and also maintain the hierarchy. That if X is not there, then Y. If Y is not there, then Z. Because you may not have person X at that point of time available. So
Thank you,
can
sir.
have few names and you can create a hierarchy. But you should not have names and then say that these people will collectively take the decision, because again there can always be a problem that your son and daughter, two people, and two of them cannot collectively take the decision.
Thank you.
Thank you, sir. Thank you, sir. I think Dr. Manjula has put on questions twice in the chat box. Madam, can you unmute and ask the question?
Excuse me, is it audible?
Yes.
Sir, my question is whether I've been breaked in between the lecture because of emergency. Sorry to say that. Sir, there is a life registry, no? That living will registry. It should be kept in ICU always. Living will registry should be kept in ICU always.
Where will the living will registry be kept, Nikhil sir? That's the question.
No, that is with the custodian.
With the custodian,
Custodian will have
who has been nominated by the government.
by the government. So I will tell you, in our state, factually they have appointed, like say for example in Municipal Corporation of Mumbai, every ward's medical officer, every ward has a medical officer's post in the Bombay Municipal Corporation. Okay, so they have created every medical officer of every ward as the custodian. So he is supposed to or she is supposed to keep the document. Now that will become available online. So when the relative will inform the treating doctor that such and such document has been made and give the copy, the job of the doctor will be only to authenticate, so he can go on online and just cross check that this document is an authentic one or not. That's it.
Thank you, sir. Thank you.
Doctor, to add to that,
Basically,
Yes, sir.
basically, I mean, which hospital will you keep, right? Because I mean, I might go to Delhi, I might go to Bangalore, I might go to any place in the country where I might require such kind of a service. Is it necessary that I will go only to XYZ hospital to die or in that condition? I might go to any hospital, or my relative might take me to any hospital for that matter. So you can't have all hospitals having all the data of all the people, no?
Anand sir, you wanted
yes,
to add
Doctor.
something.
Just to add to what Dr. Datta was saying, the living will can be given to anybody in the family apart from the custodian. It can be given to your spouse. It can be given to the number of people you have named in the living will. They are called decision makers or surrogates. So they can be named. The living will copy of that can be given to them. This is the giving to the surrogate is only an additional thing which has been thought about by the Supreme Court to make sure that there is no hanky-panky stuff which goes on, so that tomorrow somebody doesn't challenge it and say it's not his handwriting and things. So that's only an additional safeguard. But for the purpose of ease, it can be given to the family members or anyone who's been named as a decision maker in the living will.
Correct, sir.
Thank you, sir. Thank you. If there are no more questions, we'll go in the reverse order.
Yeah. Ravi, I think,
Sridhar sir.
இது வந்து this is more like a triangle of responsibility. First, the decision maker in his own free will, he plays a will, and the next will be the next immediate will be the family who are brought into the will letter by meaning of custody. I mean, as evidence, eyewitnesses are like that. The second point of the triangle will be the hospital. The hospital should have a committee, like they have an ethics committee. They should have a committee for this. And in that committee, there should be an outsider, non-doctor. As somebody mentioned, I don't want any of the transplant. Karthik said, none, I don't want any of the transplant people in. So the committee can have a non-medical philanthropist or patron or somebody who is high in the society, and that can be one way of checking. The third point of the triangle will be the judiciary, where the role of the custodian comes. I think this sort of a triangle will ensure that this act of right to die will not be misused in future criminally.
Thank you. Dr. Tandon Pass HSG is there in the webinar. If he can unmute and come, we'll be happy. Tandon sir.
Yeah, thank you. Thank you, Dr. Ravi Shankar, for a wonderful session. For the last many years, since I'm active in IMA, I've been attending a lot of international meetings during my tenure. And every time in every international meeting, there was a discussion on EOL and active and passive euthanasia. And from all the world leaders, you'll find different perspective. But the consensus never came. And always there was the ethics, the medical ethics, that we are the protector of life, not giving death. So we cannot accept all these things, whether passive euthanasia or active euthanasia or EUL. But as the things are changing with so many things, I mean, even the most important thing is this organ transplantation and otherwise. There's so many facilities are available to pull on the life of a person on mechanical ventilators, all those things. Those things were really causing problems everywhere, and people are getting benefit of organ transplantation and all such issues. So things have become very important that they should be discussed, but the discussion should reach to the core members of medical fraternity, irrespective of their Indian Medical Association or any other person, because these topics have got too much relevance in present scenario. And most of the times, public is accusing us only that we are pulling a dead person through the mechanical devices for making money. So these things, when come into the domain of public, and then public realize that the doctors are helping them, probably that can create a good relationship. So our aim should be that each and every doctor should be aware about all these things, which are really coming nicely, though the legal action has come from Supreme Court. The government may not come with any policy, but they can help us in creating certain parameters where everything can be done. And then most important thing is the safeguard, the protection and immunity to the doctors who are involved in such process. That should be very clear to everyone, because most of the times it becomes difficult to take a decision or take a call or even to explain that, look, such and such is the thing, it is better that we do not do anything. And then the family may say, okay, family may take the wrong side of your suggestion. There's so many problems. But the awareness of everything, whether it's EOL, is the living will, or active is euthanasia, or passive euthanasia, to the doctors and to the public, can change the whole scenario. I'm sure these things are a new information for everybody, but it will gradually keep on increasing and everybody will start accepting, because you have so many things to prolong the life, which may have any use or which may have no use. There's no point keeping alive a vegetative person. So these things will help those people who have been suffering and who have spent a hell lot of money on all these things, because we cannot do anything. We are helpless. If somebody says, okay, don't put ventilator, and say everything is in writing, you have given, start ventilator. How can I now take it up? So those things are going to be good for the public. They will understand, the doctor will understand everything, and the life will be better for everyone in future, I'm sure. So you have to take, Dr. Ravi Shankar, this initiative you have started from your state. I think the lecture which you have asked Dr. Datar for your bulletin for Tamil Nadu, I'll say rather take it to your Tamil Nadu and send it to JIMA as well for the publication as the public information,
Yes,
as
sir,
the
yes.
doctor information, and even to your health. Even a Hindi version can get to Aapka Swasth and your health English version. So everybody will be aware about all these things which are coming. Though definitely is coming, appearing in national dailies and everything is being discussed. But the reach of our journals will be much more to the medical professionals, and probably it will help to the public as well,
I think
because the Aapka Swasth goes to the public health.
I think, Raman sir, it's a good idea. Probably I can send an article to JIMA. Ravi Shankar sir, please guide me. I will send one article to JIMA
Yeah, please.
because
So
I
that
have
will be
not,
great help.
I think it's a very good suggestion.
Thank you, Tandon sir. Thank you.
Thank you, sir. Thank you.
Dr. Saranavale's question was answered already on the chat box by our star speaker, Nikhil sir. If there are no other questions or anybody to offer their comment, can we go on the reverse order? Can we ask Dr. Sridhar sir to give his final remark?
I have done it, Ravi. I have
Oh, you're
mentioned the
enough with it.
preamble.
You're enough with it.
No, triangle. I have mentioned the triangle to ensure safety and security. See, the legal, the family, and the hospital. They have to form a triangle and see that this is not abused, like dowry harassment, other cases of other laws are being abused. And if you expect the government to come out with a law, I don't think so, because they have more pain in the neck than just this. They are least bothered about this medical aspect. And I think it will be up to us, like Anand David sir said, we go step by step. First, approach the government and then the court and get it done for the sanction of custodians. Let us go ahead with it. I think the road is made now. It's for us to trek it.
Thank you. Thank you. Gauri Shankar, our finance secretary. If he is free. Karthik, your final remark.
Yes, sir.
To take
Sir,
forward this whole concept in our state.
Sir, I would be I'm very much honored that you've taken this as a very important topic. But one point I really want to tell, sir, we have to take this forward, but with the word of caution. The word of caution is the most important aspect here, because that is a thin line between the genuine hospitals and the fellows who want to make money with this. In this, I would be very directly telling that there are a lot of hospitals who are doing very genuine practices and also ingenuine practices also. But as an organization, we believe in the structure. For that structure to be very successful, I feel like the controlling authority of whatever is happening should be a person who has a medical background, but definitely not involved in the process, or he should not be a beneficiary. That is the natural justice feedback mechanism. You can take any example for this, sir. I would say, you want to make any change, you want to do anything, who decides that should have a knowledge but should not be the beneficiary. If this is followed, I'm sure in our state we will be able to impress upon the fact. For instance, I'll tell you, liver transplant or whatever transplant is not done by small and medium hospitals. And in our state of Tamil Nadu, 90% are small and medium. Corporates do it. I really welcome it, sir. But the governing people on the laws are mostly the corporates. But when it comes to this transplant, without any bias, who has to decide this? Definitely patient and their family. And if at all an opinion, who is not biased? Because I would openly say, because if you're governed by the government, you have a government bias. IMA is a non-biased body. And to take it successfully, we can definitely fight and take this beautiful concept. What Nikhil sir has told is fantastic, Ravi Shankar sir. We'll take it forward. But one thing, it should be governed by people who are not involved in this financially at all. That is the one dictum which will have a natural justice feedback mechanism. So whatever I decide is not even a rupee to me. Makes it genuine. Even I am sure in the consumer court, if you get the fee, you're liable. If you're doing it free, you're not liable. That is the natural justice in my understanding. Correct me if I'm wrong, but I always been thinking so. And to take this further, it's a beautiful initiative, but it should not become a business, but it can be taken very beautifully so. And this will be a foundation step for that. We'll definitely take it up. And for this, I am sure we will let us all work together to take this further. But the principles of governance should be by people with the background who are not beneficiaries of the system, but definitely only our doctors. And I would say in the private sector. And for this, I'm ready to take it up and work for this. That is my view, sir. Thank you. Thanks for the opportunity. I'm sure Nikhil sir has something to say. Yes, sir, I'm open to you.
I actually have not understood. Basically, your whole discussion is primarily from the organ donation perspective. currently the discussion or the presentation that I have given has nothing to do with organ donation.
No, sir. I'm telling you, there's a link. I'll explain to you. I'll explain to you, Nikhil, sir. You know why? Because
one second. It has got to do with advance directive. Now, advance directive, that's what I said, that advance directive is primarily made by the person himself when he is in the best of his capacities. Okay. Now, if I am not making my advance directive, chapter is closed. Nobody else can do anything about it. Secondly, I have made my advance directive. I have registered it with the custodian. I have given the copy to my relative. My relative is take it to the doctor. In other words, the patient, relative, they are the ones who are going to inform the doctor that such and such thing exists. And then the next question of doctor taking further action will come into picture.
yes, sir.
If we keep organ donation away from this, I understand that organ donation can make the things very shady.
Sir, can I explain, sir?
Here, I don't really find any reason why should.
No, I'll tell you why. I'll tell you why, sir. I'll tell you why I'm bringing this connection. I'll explain to you. See, in Tamil Nadu, we have something called a family security scheme, which means any doctor dies, a tune of 18 lakhs amount is being given. Because we have 9,000 members as on date. That is the principle. We wanted to give a very, very high amount. And I know there are so many senior doctors who have told, please don't do that. If it is too high, children may also close us just for the money perspective. So what I'm trying to say is, sir, this point, what I'm trying to again and again tell is nothing to do, you may see not a connection, but what I'm trying to connect to you is that people will make advance directive come to you for money. The person will say, I'm willing to do this, I'm willing to do that, and everything will be bought by money. For that not to happen, something should supersede that in the next level. That is my only concern. That is exactly what I'm trying to pitch.
So the law, the misuse of the law that is being brought is in the apprehension of our state secretary.
I don't really foresee, with due respect to you, sir, I don't really foresee that I am today in a conscious condition, where I am making my own advance directive. I am not at all in a vulnerable condition. I am absolutely hale and hearty, and I am on my own volition, I am making my own advance directive. So I don't really see any reason for people to kind of force it upon me for whatever schemes or whatever insurances are there or whatever. Because if I only don't make it, whosoever my relative wants me to die early or whatever, but
yes, sir, no, sir. See, let me ask you a question in this. So, what is the final directive? It is the last directive. What you say, this is my final, right? Because I'm from a family of lawyers. I know so many people who have written their property to the caretakers, which was questioned, and it is still in the court of law down south beyond Madurai, where it has happened because only the caretakers have enticed them to write properties even in their names. If something is not registered and can be done, is still questionable, which is there in the people's mind. I'm trying to impress upon you the fact that this is a problem which is there.
Misuse of the law does happen in the society.
Yes.
I think Nikhil sir is on a broader sense trying to make things easy for the family and the hospital, and Dr. Karthik Prabhu, our secretary, is trying to curtail the certain things that misthings can happen in the society.
Sir, point accepted, sir.
Yeah.
Point is complete accepted.
Yeah. With both these things, we will ask our advocate Anand David sir to proceed forward with his final remark as well as how to take forward. He is going to give us in the course of time to the state office. And your final remark, Anand sir.
Thank you, Doctor. I think what we can do to take it to the next level is maybe we can put together a very brief, clear, articulate SOP, and then have it circulated in the IMA and among the doctors, so that they have points 1 to 10 to follow in a case where a living will is produced, or what is the living will. That is number one. Then number two is as far as taking it to the government is concerned, we need to start by giving, Dr. Kanava Sabhabadi said, we need to give a representation to the government, and then wait for some time, then again follow it up with another representation. And if suppose they do not give us a reply or do not act on that, and then immediately we can approach the High Court, and the High Court will be only very quickly, they will give us a direction to implement it.
So I think you should file RTI.
Yes, we can start by filing an RTI, and
That's what I did. I just simply filed an RTI. I just simply asked that according to such and such order, give me the details of custodians.
yes.
They answered that we don't have custodian. That was more than enough for me to approach the court.
Yes. Maybe we can start with an RTI, then give the representation, and then approach the court. I think that will be a sequence.
Thank you, Advocate Sir, Anand Sir. We'll proceed as you say. Before Dr. Kumar's vote of thanks, may we have the final remark by our State President, Dr. Singatuan Sir.
Thank you, Ravi sir. Really, it is a fruitful discussion. Living will is the important one, but as Dr. Karthik Prabhu pointed out, the persons who are dealing with the case should not be the judgment people. So the extra person who is not at all involved in this will, he is not at all beneficiary, should be the member of the committee, so that he can assess everything and have the right thing to be done. Social justice has to be done. So it is a discussion point, and as Mr. Anand David pointed out, we have to make it in the point. We will discuss it in our forum, and we will decide it in later. Thank you, sir. Over to you, sir.
Thank you, State President Dr. Kumar, for the vote of thanks.
Good evening, everybody. Thank you, Dr. Nikhil, and especially Dr. Mr. Anand David, sir. This has been a wonderful session. Selective and good session. Last month it was ophthalmology, the previous month pediatrics, and the legal committee has got its own important, and members are very much benefited. We will again proceed every month with this, and I thank the office bearers for encouraging the legal team. Thank you, everybody, especially our chairman, Dr. Ravi Shankar. Thank you.
Thank you, Kumar. Can we close the meeting, sir?
Thank you.
Thank you, Nikhil sir.
Thank you,
Nikhil
sir. Thank you, sir.
We need your article.
Thank you, Nikhil sir. That was fantastic.
How to put it in GMA, sir?
Yeah. Sure. Karthik was telling something.
Thank you, Nikhil sir. We'll not only in GMA, in TIMA, we are so happy that Nikhil sir has taken so much of steps. We're just telling our concern so that it really goes constructive. All the hard work what he has done, and as supported by Ravi Shankar sir, should really come up well. We'll do it, sir.
Thank you all. Thank you, Anand sir.
Thank you, sir. Thank you.
Thank you, Nikhil ji. Thank you, Anand sir. And congratulations, Ravi ji, for coming out with one more program. Good program.
Thank you, sir. Thank you, Sridhar sir.